In a bit of a change for my art law channel, some actual art law for you, which hopefully you'll find interesting. But first of all, I need to tell you two little short stories. The first concerns Elizabeth Taylor, who you may remember, the actress of Violet Eyes. Well, when she married Richard Burton for the first time, her dad, he was a famous art dealer, and he said, okay, pick a painting as a wedding present, I'll get you it. And she picked a particular painting for a wedding present, and her dad bought it at the auction for her. Many years later, it transpired that that painting was actually a looted artwork. It had been stolen by the Nazis from a Jewish family in the prelude to the war. So obviously they saw this, this came to light, because there's a sort of retrospective, and they said, oh, that's our painting. So they sued. Unfortunately, they came up against limitation. What's limitation? Limitation gives you a certain amount of time to bring an action. Now, to sue to get a painting back, over here we'd call it conversion, but in the US they call it replevin. I like that. Over here, if you want to get some property back, you sue in conversion, and they either have to give you the property back, assuming you win, or they have to give you damages in lieu of, say for instance, the property is no longer recoverable or something like that. They have to give you damages in lieu. In the States, they actually split that up. A claim in conversion is give me the money in lieu, but if you actually want the thing back, you sue in replevin. But anyway, they got knocked back because they said, aha, yes, we accept that you've only just found out about this. However, when Elizabeth Taylor and Richard Burton got married the first time, this was in all the society pages. So if you're reading all the sort of high-end magazines and gossip columns, you would have seen there that it mentioned that she had this painting. So the test is not when you found out about it, it's when you could have found out about it. And they said, time starts running from the first time you could have known about this, and you could have known about it if you'd read the gossip columns. So they lost their claim, and she got to keep the painting, much to their annoyance. Then there was another case, more recent case, where again it concerned some looted, they're called the Guelph treasures, a series of very interesting and possibly priceless works of art. And again, the family who they'd been looted from, they found out they were in the possession of the German government. Now, the family lived in America, so they sued in America. But rather strangely, this went all the way to the Supreme Court. And the Supreme Court came back with a ruling that did surprise a lot of us, because they said, yes, we accept this was looted from you. But at the time, the laws in Germany said people of your faith and ethnicity, I don't want to sort of trigger the algorithm, they have no rights. You're not allowed to own property. So this was completely lawfully taken from you, and therefore the German government don't have to give it back. Now that was a bit of a surprise, because the whole point is, well, I thought we'd agreed at the Nuremberg tribunals that all those laws that were in place at the time, they were deemed to be so reprehensible that they weren't proper laws. We had an entire series of trials about this. We had what we called the judges' trial. That was one of the Nuremberg trials. There was the main Nuremberg trial, but then there were lots of other trials. And they had one called the judges' trial. And the issue there was, if you were a judge in sort of, Nazi Germany, were you sort of immune from prosecution because you were just applying the law as it was passed at the time, and it wasn't for you to comment on whether it was right or wrong, but we actually convicted them. So the argument was, look, we've all accepted that these laws, they were just completely invalid. So, how can you say now that actually, no, it's all fair, the Nazis, they were properly elected, and it was in their manifesto commitment that they would be horrible to Jewish people, so, there you go. And again, that was a shock. However, we now have something called, and I should remember this, but I always forget it, the Holocaust Expropriated Art Recovery Act of 2025. Now that actually, there was a similar act in 2016, but this both extends it and goes a bit further. And what that says, it just removes all these defences that people have raised. So where it comes to, for instance, limitation, what it says now is limitation runs you know, we're still keeping limitation. You've still got 6 years. However, you've got 6 years from when you found out, when you actually found out where your artwork was or who had it. It's not 6 years from when you could have found out. It's when you factually did. Also, you won't be allowed to raise the defence that actually it was lawful in the country at the time, you know, like the Guelph Treasures case, and therefore there's no claim. So basically people say, if this was seized off me in an egregious matter, it doesn't really matter what the law was at the time. If an oppressive regime puts a law in saying, I have no rights, it's not, you know, 75, 80 years later, you can't be saying, well, that was good law at the time. So it removes that as well. Also limits a defence. There's a defence called laches, L-A-C-H-E-S. Feel free in the comments to point out I'm pronouncing that incorrectly. And that's a defence that says, okay, even if technically they're within limitation, they've dragged their feet for so long, they've acquiesced, as we say, to the situation, and it's too late for them to complain about that. So it also makes the defence of laches harder. So I'd be interested to see, I suspect this will get passed because it has pretty much bipartisan support. And like I say, what that will mean is, the Act has a sunset clause. It probably won't last forever. It'll be like, it might well be sort of, okay, we're going to keep this on the books for 6 years. Because that's with the last one they did that, like I say, they did that in 2016. That expired, but they're now renewing it with this Act. So it'll be very interesting to see what happens there. I mean, there've been similar things actually. They did a thing, you know, in the post-Me Too thing, where they extended limitation, or they got rid of the limitation defence in cases where people were coming forward about historic abuse, and they said, okay, fair enough, if you can show that there's a reason why you didn't do it at the time, and we'll accept the fact that you didn't want to rock the boat, or you didn't want the adverse publicity, or you didn't want the abuse, then we'll extend that. But there you go. So it's an interesting one because, like I say, technically speaking, all those initial cases, like Elizabeth Taylor, you know, that it was perfectly lawful, she got to keep it, and same with the, you know, the German government, being the inheritors of the Nazi state, get to keep anything that the Nazis stole as well. So you can see why, even though that was legal at the time, people obviously thought it was a little bit unfair. So there you go. Just a little aside about Elizabeth Taylor and Richard Burton. As you know, I do a lot of the advocacy training. And one thing they did once was they set up a mock trial where they got some family law experts. I don't really do family law, but they said, do you want to be one of the actors? Do you want to be the witness? And the mock trial was based on Who's Afraid of Virginia Woolf, and I was the hubby. So I was Richard Burton. It's obviously not quite the looks. And my lovely friend Deborah, a very senior barrister, she played the Elizabeth Taylor role. I have to say, very much, you know, she's a lot more glamorous than I am. Shout out to Debs, I'll send her this. But we got so into character that it just became a disaster because Deb's lawyer had to declare her as a hostile witness because she just went off on one. But and I was basically they're going, are you drinking in this? And it's like, well, yeah, because that's the whole point, isn't it? That's all in the papers that I have a drink problem. And so yeah, but didn't expect you to really actually drink. And it's funny because they videoed all these trials. You know, they were all done remotely, and they were meant to be up for the students, and I noticed that of all the mock trials they haven't actually put our one up, so there you go. But I would remind people that that could still be entered for the Oscars. We just need to stick it in one theatre. But there you go. As always, hope you found that vaguely interesting, vaguely useful, vaguely accurate, and it's just nice to actually do some art law on my art law channel.